You have questions, we have answers. This is Jane Miller.
And this is Ken Miller. Welcome to our show, all about real estate with Ken and Jane. Today, the topic of the day is landlord and tenants law. We're going to try to break down some of the commonly asked questions about leases in New Jersey. I should preface this by stating this is intended as general guidelines based on our knowledge of the New Jersey landlord-tenant law. It's not intended as legal advice. If you have any particular questions, you best consult an attorney. Again, it's just general rules.
This is not legal. We're not talking about the law. We just talk about as a real estate agent, the frequent asked question from our clients.
And also from listeners that have emailed us about some questions. So I've compiled a list here. We'll get through them the best we can.
Yes.
And let's get rolling on it. So the first thing we want to start with is rent. When and can the landlord raise the rent? Well, the answer is yes. The landlord can raise the rent, but only at the end of the lease term. They can't raise it arbitrarily. So the rule would be if you're on a month-to-month lease, the landlord can raise it giving a month's notice. If you're on a term lease of a year or longer, at the end of the term, the landlord can raise the rent. However, that question is double-edged. It has the second part of the question is how much can the landlord raise the rent?
Often I get a call.
Often is we already just covered, but how much? And the answer is it depends where you live. New Jersey has different towns have rent control ordinances. Some towns like East Brunswick, you can only raise the rent by the applicable consumer price index, which is known as the CPI. Other towns don't have rent control. So you can raise it as long as the rent increase is not unconscionable. And what the heck is unconscionable? That's a good question. There is no definite answer, but it would be exaggerated or so out of the ordinary that it might be like if you try to raise it 25% or higher, that could be considered unconscionable. It all depends on the circumstances.
It depends on the reason, Ken. If suddenly the HOA, I know during the some natural disasters or human-made disasters in Florida years back, and then a lot of high-end condo have to raise a lot of money for the capital, for the reserve. So if you're suddenly your HOA went almost 50%, so I mean, as an owner, maybe raise amount of the rent it seems like explainable. I'm not saying reasonable, explainable. Why?
Yeah, it has to be defendable. I think that's justifiable.
Justifiable.
So maybe in some cases 15-20% could be justified.
But have you justify? I mean, You had a law background, so your word is much more accurate.
Well, in the law, there's always a terminology like unconscionable, reasonable, the reasonable man test. When you're talking about criminal and self-defense, would a reasonable person under those similar circumstances react by shooting the person? They always are torts. They always refer to those, and a lot of times it just depends on the facts.
I think a lot of time it's like just common sense,
it depends. Yes,
common sense.
So sometimes people say, "Well, what's the rule?" Sometimes not everything in the law or leases or landlord-tenant. There's not a specific rule that says, "Oh, you can deduct." But a lot of it is a judgment call. We're going to talk about like the security deposit and when you damages versus normal wear and tear. That's a very good example. But we're jumping ahead. But that's where that comes into play as well. So that's the rent. So it really depends. You have to check. So the best thing you can do if you're a landlord or tenant is check with your town clerk and ask if there's any rent control ordinances in place with the town before you do anything with the rent.
Yes.
To protect
always check with the township. Once again, when you have a tenant, right, the landlord out there, you must register with the town because some town they have CCO, certified occupancy for inspection for the tenant. Some town only had a fire inspection for the tenant. But if your town requires CCO, obviously you already made a formal application to the township. The township where your property is rental property, they come inspect, give you a certificate to before the new tenant move in. But for the town doesn't, and then you have to inform the town. That's landlord responsibility. You must inform the town. your property is a rental property.
Because if you don't, and God forbid, there's an action for eviction, which can be filed by the landlord if the tenant fails to pay the rent without any prior notice. You can file for eviction. However, if the property is not registered, then that's a defense to the eviction statute. So it's important from that aspect that the property be registered. Otherwise,
and also if you have a dispute with neighbors, they can call the township on you too. So just be a good citizen, not because you don't want to be in trouble. It's just voluntarily do the right thing. Register with the township. Yeah. Consult your township, consult your real estate agent for advice.
Yeah, and most of the time, at least in the towns we work with, the registration form is free. You just file it. I usually bring 2 copies, give one to the township, ask the township to stamp one.
They don't want to stamp. You can take a picture of the one.
Just so you prove that you filed it and then scan it in, keep it with your rent. And it's only a one-time filing. It doesn't matter if the tenant changes.
5 years, I believe.
Well, it depends on the town, yeah. But it's a one-time filing for the landlord and you can go through multiple tenants, but you may have to check with the township. You may have to renew it periodically.
Yes. Yeah. Once again, the number one advice today we give you, check with your township.
Absolutely.
That's you get the right answer. And don't say, well, I always do that. I never had a problem. That's not a good excuse. My neighbor said, whoever said, just pick up the phone, speak to the township. That's the right source to find out.
Mm-hmm. Yes. Right. All right, let's switch gears. Let's talk about the security deposit in New Jersey for a residential. So the question, Jane, is in New Jersey, what can the landlords charge for the security deposit?
Maximum 1.5 months.
Very good.
I can do that in my sleep. You know why I can?
So,
years back, 16 years ago, when I just started real estate, I remembered, I can't name the company, obviously, but our brokerage had a weekly meeting. So one agent get sued. So the company gets sued because of a security deposit. That's why I learned a lot. And then I try to find out, where do I get more information about rental? And I come across a booklet called, the all you need to know about the rental. Truth in renting.
Truth in renting. And that's published by the DCA. We're going to cover that at the end. But that's something that's mandatory that the landlords and the tenants must have and read before they, or at least give them the opportunity to read it before signing the lease.
Absolutely. Yes. But as an agent myself, I learned so much just by reading that document 2-3 times.
Yeah, and while we're on that topic of the truth in renting, that document is available for free from the DCA website, dca.gov.
If even you type in the Google,
just Google
truth in renting,
New Jersey, it'll bring you to the DCA website.
They will bring up that document. That's how I found it.
Yeah, and that gives a lot of questions and a lot of good stuff we're going to cover, time permitting, at the end about what situations when the lease can be broken, if there's a disability, a death. Domestic violence. It covers all the things about the security deposit and other stuff we're going to cover. So
I mean, a lot of time, Ken, I found our client said they want to be a landlord. I always tell the client, being a landlord actually is almost like a part-time job, right? You still have things to do and rules to follow. So it's not just buy a house, forget about it. There's truth. You have to know the law. Start with reading, understanding the truth in renting. That would answer majority of the questions.
Right, you just have to read that.
You have to read it and understand it, because I have a lot of clients ask me questions because we always give them the documents. You always give them before anything, but sometimes they don't read. They still call me, but that's okay. They call me after or before the conversation. I said, hey, that's all in there, but let me help you. But before the end of the conversation, I said, hey, you have a bad time, just instead of watching TV, just read a few pages, right? Yeah, but that document is extremely useful for the landlord and the tenant.
Right.
Yeah. You know your rights.
So the security deposit is intended to be to secure the property in the event that there's damages done by the tenant, and it's to compensate the landlord, if they have to dip into that. But so we're going to talk about that and the return of the security deposit now. So normally, the security deposit must be returned to the tenant within 30 days after the tenant vacates the property. That's the normal rule, and you're entitled to, and also the security deposit must be placed in a landlord-tenant a special account that's an interest-bearing account. So at the end of the lease term, the tenant is entitled to the return of the security deposit plus the interest that accrued on that amount. Now, the question is, when can the landlord deduct from the security deposit?
I think before that, Ken, right? Just before that, when you take a tenant, they give you a security deposit, you must promptly open the account.
Yes.
And you must inform your tenant the which bank, the account number, and the receipt of your deposit.
Yes.
So that's part of the rule. If you fail to do so, and the tenant can report you.
Yes,
that's
right.
That's once again in the book of Truth in Renting. So if you read that, you will avoid a lot of issues down the track.
Right. You have to send the tenant written notice of the account, the bank, the account number, the amount, and show the deposit made, and then and basically it's a custodial account, so it's held on behalf of the tenant.
The tenant owns the money.
The tenant owns the
they
money,
have
and
rights to know.
They have a right to know where it's held, and they have a right to the return of the money.
Yes.
Now, if the only exception for that is if there's unpaid rent at the end of the term, or there's damages beyond normal wear and tear. Now we're going to get into the topic of damages versus normal wear and tear, which gets into the gray areas, and that's a very important thing. That in New Jersey, they look at damages very strictly. What are we talking about when we talk about damages? Well, based on my research and based on court decisions, damages things would be like a broken window, other than stuff that's really damaged, maybe holes in the carpet, or cigarette burns in the carpet, or a floor that's there's really got to be.
I have a very good example for that, right? I mean, if you listen to the landlord, you think she or he they are reasonable, but court think differently, and the tenant think differently. For example, the landlord just update the house, and before the tenant move in, obviously. So they invest a lot of money to do a special flooring. It's like a high-end laminate. Mm-hmm. It's very expensive, special high-end laminate. So the tenant move in, somehow, somewhere, there was a portion of that laminate got damaged. Right. I think what happened was that was in the it's a condo, so it's in the kitchen area. It's a first floor condo. So when the tenant cooking or something, or the whole pot, of the soup or whatever fell off. Mm-hmm. So near the stove area, that pieces got terribly damaged.
Right.
So that was, but unfortunately, that kind of type of laminate is no longer, in production. No. So the owner bought it at that time for, for a special closeout or something. So they couldn't rematch it. By the way, the whole condo was the same. The laminate, very high-end laminate. So the portion got damaged. So the landlord felt they are entitled of the replacement. First, they think is the whole house, and then the tenant fought back and said the other room not damaged, and then they said at least the kitchen and the dining area, because there's a condo open floor plan, so you can't just change a few pieces. You pretty much, it's a laminate, it's a naturally click, so you can't just you have to replace the whole area.
And I'm glad you bring up that example, because that gets right to the point, because it gets to be a very gray area, and there is no easy answer. And the landlord saying, hey, I had no choice. I had to replace that whole section because I couldn't match that damaged section. So, I had no choice to replace the whole kitchen.
And that's a click system too, Ken.
Right. And then the tenant is saying, hey, but I only damaged a little section. But so it's like
maybe 4 square feet.
And I had a similar situation with a client that went to court on a similar something analogous to that. And so go ahead, finish your story.
And then at the end of the day, the landlord first of all said the whole condo. I said absolutely not. That's just you're gonna lose definitely. And then the landlord said at least the whole area, right? Because it's open, the kitchen, dining, and living room, because it's a condo, so they all together. So the tenant said no, that's only damage in one area. I know you can't match it. But that's at the end. I told the owner, you guys can go to court, but the court may look at it differently.
Yes.
So I think at the end, I don't know what happened. I think they possibly went to the court. I think the court only gave them the square footage.
That's what happened in my particular client's case. They spent a week in court because they had a floor damage issue too, and they replaced the whole floor. And in this particular case, the judge ruled that you can't be enriched from the security deposit repayment. You're only entitled to replace the damaged section, and then you've got to eat that additional cost. But again, everything is fact specific. We don't want to speak for the court. But you got to be very, very careful, because if the landlord wrongfully withholds money from the security deposit, it's 2 times the damages. So if you wrongfully withhold $1,000, the court could hit you with a $2,000 penalty.
Yeah.
All right.
And also possibly the tenants, the lawyer fee too, if you lose the case.
Right.
Possibly.
All right. We're going to go to commercial break. We'll be right back after these messages. Okay, welcome back to our show. So, talking about the security deposit, be very, very, very careful with the security deposit issues. It's always best, like you said, Jane, if the landlord and tenant can settle it without getting the court involved. Otherwise, you're going to have the time, the expense, and the long drawn-out thing. Because in my particular case, the client spent about a week in court, and the judge ruled they wrongfully withheld that, and there was repercussions for penalties and things. So you have to be. So it's very important. Again, I think you have to look at it very conservatively, and you can't enrich yourself. The damage has to be really just for that damaged section. That's so.
But from the landlord point of view, they didn't enrich themselves. They bought a very high-end laminate, and the whole floor, this is a condo, not big, open.
Right.
So now they have to fix it. Do the kitchen, that section, which is totally different, the color from the rest of the open area. So that's not enriched from the landlord point of view. But the court may interpret differently. So you can take the chance, go to the court to get a ruling.
Air the facts.
Get or you just say, you know what, that's just an accident. Let's work it out. So a lot of time it's really business decision. When client call me, most of the time, it's not a real estate decision. I would say that's a business decision.
I agree. Yeah,
even to buy a house or sell a house, home inspection, you should always reach out.
It's better to settle it than to drag it out. It's just going to cost.
The time you have to go to court. The court may not be one day, as you said, it could be a week. Yep.
And one more thing while we're on security deposits, another question the listeners had is, can you charge an additional pet security deposit? And the answer is absolutely not. You can charge additional rent if the tenant has a pet. That is legal. However, you got to be careful, because if the tenant has a service animals by federal and state law are not considered pets. So it has to be, if it has a legitimately registered service animal, I'm not talking about emotionally support animal, but a service animal, that is excluded. That's not considered a pet, so you cannot charge anything.
I'm not sure the emotional is excluded, not excluded. That's really up to their lawyer to argue. But I believe, if it's service animal, 100%, that's a black and white. They shouldn't charge more from the landlord perspective. Otherwise, it's discrimination. And the pet deposit, which is once again, if you read the Truth in Lending, you'll find out in New Jersey, maximum amount the landlord can hold from the tenant is 2.5 months. It's a maximum. So that's why
1.5 months.
2, because your rent always in front.
Oh, okay, that's
total. So if you do the math, 2.5 in advance. So you already the rent always in advance. Yeah. So maximum you can do for the security deposit is 1.5 months. If you charge more the pet, over 1.5, you're illegal. So that's 16 years ago when I started. They charged the tenant like $300 or $200 for the pet security, and then the tenant didn't say anything. They moved in and then they sued. They reported. And then the landlord lose big time. The landlord cannot even hold the deposit at the end. So that's I learned the first lesson. That's why it pumped me to see where I can find these rules. I'm brand new in the business.
Yeah.
I don't want to make a mistake. What do I do? So one of my colleagues said, read that book. That was a great advice. So I read it 2-3 times to understand it.
Yeah.
Yeah, I still benefit from that 16 years ago ratings.
Yeah.
Yep.
So now we're going to move on to the commonly asked question is, can a tenant withhold the rent if the landlord doesn't make repairs? This is a loaded question.
Yes.
And it really depends on what the repairs are. There was a famous landmark case, Marini v. Ireland. It went to the New Jersey Supreme Court in 1970. And in that case, the tenant, Ireland, had a cracked toilet. I guess, I don't know, I didn't read all the details, but it looks like the toilet wasn't usable because there was a crack in it, so they couldn't flush the toilet. They notified the landlord. They gave the landlord, I guess, what was determined to be a reasonable time. The landlord did nothing. So the tenant went out, hired a plumber, fixed the toilet, and then when the next rent month came, the tenant deducted that payment from the rent. So the landlord was furious. They filed an action in court for an eviction because, for failure to pay the full rent due. So this case went all the way up to the Supreme Court.
Oh, my God.
Okay? So the court held that based on the facts in this case, that the tenant was justified in withholding the rent because it was an essential repair that was needed to the habitability of the place. And that became so basically what the court did with this case is they created the implied warranty of habitability, meaning the landlord has it. Before that, the doctrine was kind of like caveat beware, emptor, buyer, tenant beware. It's up to you to maintain the property. But no, the court said with this case, there's an implied warranty of habitability that the landlord the tenant has a right to have a house, a unit or apartment or a home that's rented that's habitable, meaning it has running water, free from roof leaks, working plumbing, working electric. So in these very narrow circumstances, if the tenant, but there's a lot of groundwork a lot of rules have to be followed. Even if you have an essential repair, you have to give the landlord notice. The landlord has to have a reasonable time to make the repairs. And if and only if the repair is an essential, vital element, the landlord fails to repair it within a reasonable time, then and only then can the tenant initiate the repairs, pay for it, and deduct the rent.
Once again, Ken, I assumed this case is based on they only had one bathroom in the property.
Probably.
If
back
they had 2 or 3, the landlord can argue, said, well, what happened to the other bathrooms, right?
Right.
So, but once again, a lot of time is common sense, right? We, as a landlord and tenant, first of all, we are not against each other. Okay, we should work together. It's a partnership relationship, right? I always joke. I said, when you take a tenant, the landlord-tenant married for the period of the lease term.
Right.
So you are married for that period of time. Sometimes I had a lot of wonderful, wonderful tenants. So when they were there, they take care of the place better than the owner themselves. So the owner is so happy. And recently, I just have one family. They stay there 3.5 years. Now they have to move back to New York because they came during the COVID. Now they have to move back. They have to go back to work now, so they won't have to go back. The landlord was so upset. They say, Jane, they're the best tenant I ever had. The place ran out for over 10 years. They're the best tenant.
10 years, wow.
Over 10 years, but they only stayed 3.5. Yeah. So they had a 4, 5, 10, 2, 3, 4, 5 tenants in total, but that tenant is the best. They always take care of the place. They make it improvement. They always report the landlord, ask approval first, and they make it their own. So it's the best tenant. So once again, it's just a good relationship.
Good relationship,
yeah.
Good communication between the landlord and the tenant. If there's a problem, notify your landlord. And again, be very, very careful.
In writing.
You'd have to consult an attorney before any tenant listening out there takes this initiative and says, oh, the landlord didn't fix X. I'm going to deduct the rent. This is a very narrow interpretation. It's really for essential repairs. Now, we could argue if the air conditioning breaks, is that essential to living there? Probably not. Because air conditioning, there's people that I grew up without air conditioning.
I did too.
Yeah. So I don't think that's a vital thing. If there's no heat, if there's no running water, if there's no plumbing, or if the roof is leaking and there's water gushing in, those could be examples of things that the court could look at that are essential, having, to habitability. That's
but
what we're
once
talking
again,
about.
Ken, I understand, all these problems, but before, just like a marriage, right? Before you get married, you should get to know who you're married with. If you're a tenant, you should get to know, ask the previous tenant or ask the agent or ask the landlord a few questions, right? Set up that understanding, what you get you into. So we represent so many landlords, over 100 landlords over the years. Highness was almost 150. We always, get involved. If any problem, the landlord can't get in touch with the tenant can't get in touch with the landlord, they always know they can call us. We will help the landlord. We will. How many times, unfortunately, I have to make decision on behalf of the landlord because in the winter, the heat shut. 11:30, I got a phone call. What do I do? I couldn't find landlord. They were overseas Chinese New Year on vacation. Mm-hmm. So I have to quickly in the morning to call the emergency HVAC contractor come check it out and do. So that's you have to do. Like you said, Ken, that's essential. Yeah. How do I know that? I read the Truth in Lending.
Yeah.
AC can wait. The heat, it can't, especially in winter.
Can wait.
Yeah, but sometimes you can't. Once I had something which is more questionable according, to the circumstances. There's a refrigerator. You didn't grow up with refrigerator. I didn't grow up with refrigerator, but they had a young baby, so they need refrigerator. So I had to go out to buy one that day. So, but once again,
that's why these things are so fact specific. Because you order a refrigerator is an essential service. Well, it's not essential. You could order. That's
but they have a young baby. The milk has to be in there.
Right.
The formula has to be in there, and the medicine has to be in there.
That's why the best thing is to be proactive and resolve these through communication between the parties or their agent and get it done. Yeah.
Absolutely.
Yeah. Without letting it get to this point where there's no communication. Again, you have to give the landlord a reasonable time.
Yes.
It has to be in writing, and they have and what's reasonable? That all depends. We don't have the answer. That
now it's so easy. You can send them a picture. You can send them a text.
Yeah.
That before you have to write a letter, mail them, or call them. They don't answer. You don't know where they are. Now it's communication is so easy. Just establish that before you move in, both sides, the landlord and tenant.
Yeah. And there's and again, we're almost out of time, but the Truth in Renting booklet, it's published by the Department of Community Affairs, DCA, that covers everything that we've discussed about security deposits, the type of lease agreements. You can have written, you can have oral, landlord's duty to provide a habitable, livable home, rent increases, evictions, the fact that it's illegal to discriminate based on a whole category of race, religion, sex, disability, family status, which is the law. There are exceptions to certain things if it's an owner-occupied 2 or 3 family dwelling. And so, please read that. It also covers tenants' rights when you can rightfully terminate a lease agreement due to disability illness, due to domestic violence incident, or due to housing that is not handicap accessible. There's all sorts of rules and notices given for each of those. But that's a great document. So please, if you're a landlord or tenant, please read it thoroughly and, ask questions if you don't understand it. So we're out of time. Hope you guys enjoyed the show. We'll see you next week.
Thank you.